Friends, in session number 22 of the series on military law, we would be explaining the procedure, the format of summary trials. It is to be appreciated that summary trial by the commanding officer and in certain cases by the formation commanders appear as an effective tool to keep the army in combat readiness by ensuring that all ranks maintain a high standard of discipline. The slide in front of you shows the three main provisions under the Army Act which relate to summary trial. It may be recalled that earlier Section 80, which empowers a commanding officer to carry out summary trial, had been studied, and this presentation should be seen in continuation of what was there in the case of persons below officer rank as indicated and prescribed under Section 80. Now, as far as Section 83 is concerned, it provides powers to officers of the rank, a post holding a post of brigade commander or equivalent, and they can deal with an officer below field rank, which means captain and below, JCO or warrant officer. Therefore, a brigade commander can proceed against an officer of the rank of captain or below, a JCO or warrant officer, and award him punishment of severe reprimand or reprimand. Now, you would recall that reprimand means warning. And next is stoppages. Stoppages are mainly used to make good where some loss has been occasioned because of the responsibility of the offender. Next is Section 84, which gives powers to area commander or equivalent. Now, it may be remembered that area commander is a post and the rank of the officer is Major General, whereas in the case of a brigade or equivalent commander, the post is brigade or sub-area and the rank may be either brigadier or Major General. Now, in Section 84, the officer who's conducting summary trial may proceed with the officers or against officers below the rank of Lieutenant Colonel. What that means is officers of the rank of Major, then Junior Commission Officer or Warrant Officer. And his powers to punish are more than what was there in Section 83. In the case of Section 84, he may award forfeiture of service for a period not exceeding 12 months. That means up to 12 months service can be forfeited. But there is a proviso. If such an officer who's an area commander wants to award the punishment of forfeiture of service for any period up to 12 months, then he has to first ask that accused that would you agree to my award or do you elect to be tried by court martial? And in this manner, the accused, if he is of the view that he would get better defense at a court martial, or the court martial alone would be able to provide him justice, may say that he would like to face a court martial. On the other hand, if he elects to the jurisdiction of Section 84 an area commander, then he may give his consent and he may be tried. The other two punishments that can be given apart from stoppages are severe reprimand or reprimand, just like a brigade commander. These are the powers of an officer who's holding the post of an area commander or equivalent, and in this case and then maybe Major General or Lieutenant General. Next is Section 85, which is available to the commanding officer, and he can proceed under Section 85 against a JCO, Junior Commissioned Officer of his unit, and award severe reprimand, or stoppages. However, this Section 85 power would not be available, cannot be exercised if the commanding officer is of a rank below colonel. Now, in summary trial, there are two forms which are important, and these two forms are contained in the book, the Bear Act, which is of Army Act. You can see it there. The two forms relate to two contingencies. The first contingency or option is when the accused gives a written consent to dispense with the attendance of witness. This means that before the trial, the accused is asked that would he be calling witnesses, and if he says no, witness is not required, then Form 1 is to be used. On the other hand, if the accused would like or is uh, in a situation where he would like to have the witnesses examined, then Form 2 are to be used. Now we would shortly see what are these forms, what do they look like, and what do they state. You see here Appendix 4, Part 1, Form 1, and it states form for use at a summary trial of officers, JCOs, and warrant officers under Section 83 to 85 of the Army Act. Now, on top, the name of the accused, rank, name, etc. is written. Number would also be written, and unit. And then it states when the authority dealing summarily with the case decides with the written consent of the accused to dispense with the attendance of the witnesses. So Form 1 would be used where the accused has written that he doesn't want witnesses to be brought, and in all probability he would plead guilty to the charge. Then the questions are asked: have you received a copy of the charge sheet and summary or abstract of evidence? His answer would be recorded against that. Have you had sufficient time to prepare your defense? His answer is written, and then charge sheet is read aloud, and a question is asked. He is arraigned. Are you guilty or not guilty of the charge against you which you have heard read? So the charge sheet is read out to him, and the summary of evidence is also read aloud, or the officer informs the accused that he has already perused it, and then it need not be read. So the purpose is that number one, accused is not tried in absentia. The trial is in the presence of the accused. He is issued with a copy of the charge sheet. A suitable time is elapsed, and he is asked that did you have sufficient time to prepare your defense? And then his answer is sought that have you done it or not? The legal language is are you guilty or not guilty of the charge? So this is in a nutshell the procedure that is followed in case of Part 1 where the attendance of witnesses is dispensed with. And the next stage there, next step is, do you wish to make a statement? If he wants to say anything, then it is recorded there. And after that, if the accused was to be awarded forfeiture of service, then that question is asked that would you elect to be tried by court martial or do you agree to my award? Then the situation of para number 5 comes, that do you elect to be tried by court martial or will you accept my award? His answer is written, and then finding is written. What award is given to him or punishment, that is written, and that with the signature of the officer holding trial, this brings the process to an end. Form 2 is to be used where witnesses are to be summoned and witnesses are to be examined as indicated by the accused, and they are heard in relation to the charge, so that in front of the accused, the evidence is brought out and the accused can even put questions to them, and the form has been prepared in that manner. The witnesses give their evidence, accused is permitted to cross-examine, and the supposing if the space is not adequate, that can be written on a blank page, and then at step 4 he is asked, accused, do you wish to make a statement? He may say yes or no. That answer is written. If he wants to make a statement on a separate page, a statement will be written down. And the next stage is if he wants to call any defense witnesses, and likewise their evidence would also be written down. Now, therefore, it would have become apparent that the rules provide, the procedure provides elaborate provisions to cater for both the contingencies where the accused wants or does not want the examination of witnesses, and the proceedings are signed, authenticated by the officer who holds the court. As I said, it may be commanding officer, it may be a brigade or equivalent commander, or area or equivalent commander. Then a relevant section 86 is also to be borne in mind, which talks about transmission of proceedings. And the section says that every case where punishment is awarded under sections 83, 84 or 85, a certified true copy must be forwarded to superior military authority by the officer awarding the punishment as defined in section 88. So whichever is the authority, which can be either commanding officer or brigade commander or area or equivalent commander, once the trial is over, then a true copy of the proceedings is to be forwarded to the next superior authority. And next superior authority not merely watches or files the documents that he has received in case he thinks that there is any patent illegality, something wrong has been done, which is unjust or illegal to the accused, then a person may intervene, such an officer, to provide suitable relief to the accused. And section 87 talks about review of proceedings under section 80C of the 87 of the Army Act. The summary trial which has been carried out is reviewed. Legal examination, re-examination of the process takes place, and if any punishment awarded appears to be illegal or unjust, then the superior military authority has three options. It can cancel, it can vary, or remit the punishment. Cancel means to bring it to an end. In vary, it may be changed, say for example, from severe reprimand to reprimand, or remit the punishment, say if it was 12 months or 9 months forfeiture, then it can be brought to 6 months or even less. Further, the officer who's reviewing the proceedings can make such other directions as he considers appropriate in the circumstances of that case. So it is not merely that he would provide relief, he can also convey his mind as regards the offense or the disposal thereof. And now, next question, who's the superior military authority for the purposes of section 88, to whom the proceedings will go? Now, the section provides, A, in the case of punishments awarded by the commanding officer, it would be any officer superior in command to such commanding officer. So, if there is a commanding officer, usually there would be a brigade commander or a sub-area commander who would be above the commanding officer, and such a person will review the proceedings. And where the punishment has been awarded under sections 83 or 84 by a brigade commander or area commander, then clause B will come into play, and there the central government or the chief of army staff or other officers specified by chief of army staff, the proceedings shall go for review to such an officer. So therefore, uh, the purpose to be or the point to be understood is that there is a systematic legal review of the exercise of powers by the commanding officer, or under section 83 by a brigade commander, or 84 by an area or equivalent commander. Uh, that brings us to certain obvious observations, and firstly, it should become that powers of punishment available to the authorities are quite substantial. So it is not that the commanding officer or a brigade commander or an area commander are powerless or they are helpless. They are not mere spectators. They can use their powers effectively to deal in a speedy manner against an offender who is said to have committed an act, an offense under the Army Act. So therefore, these powers are substantial. These are not less, and discipline would be maintained by use of these powers in a legal and just manner. And they are substantial because they have long range repercussions on the career of the offender. So they cannot be easily brushed aside or ignored. They would continue to affect the delinquent offender, and action can be taken based on the fallout of that punishment. It would also be fruitful to remember and note the case of Suresh Mehra, Major Suresh Mehra, 1991 matter, where the Supreme Court had said in the situation an officer of the rank of major was asked whether he would elect to face a court martial or would accept the award passed by the GOC. Now, this exercise having been carried out and the step having been taken where he had voluntarily opted to accept the award, and at a later stage he moved a writ petition challenging his trial with regard to this provision, infirmity or absence of this provision. Now, that was not accepted by the Supreme Court, which held that having once voluntarily opted to accept the award, it does not lie in his mouth that no trial as provided for in the rules had taken place. And where a certificate to this effect has been rendered by the officer and he was proceeded against, he cannot then disown his own signatures and say that provisions in this regard were lost sight of. And that should make it obvious that further cause of military law would be better served. There are two recommendations in this regard: that elaborate forms should be devised for transparency. There should be a space, maybe that there is an independent witness whose signatures are taken to authenticate that this is what the accused has said. And that would give not only effective and meaningful defense opportunity to the accused, but would keep record of the proceedings, and while ensuring there is transparency in the action which has been taken. This is more necessary because the consequences, as was indicated earlier, are severe, and they do affect the offender. Thank you.